saves a lot of stress later at a time which is already going to be difficult for them. So by thinking now, it'll give you peace of mind as well as help them. The kind of thing I'm thinking of, for example, is that members of our Red Cross branches might be joining our webinar today. And it's always nice to have that Red Cross Association acknowledged during a life celebration or a funeral. And it may be that the person who is your executor or is organising some things for you and presenting a eulogy, perhaps, they may not automatically think that, yes, I know Mum was a keen gardener, but maybe they just won't remember to mention the 20 years that she was a member of a Red Cross branch, and that would mean such a lot to the people in the room. So just anything that you think is relevant can go in there, all in a one-stop shop, which is this Red Cross booklet called My Life and Legacy. Key information included in that booklet. If you were kind enough to consider making a gift to Red Cross, for example, you'll find the charity's commission number in there. And this just identifies us and ensures that the gift is directed to the right cause. And for many people, you know, a gift to general purposes is something they're happy to do. For others, you might want to talk to somebody like myself, somebody who works in this area of gifts and wills, just to ensure that the wording truly reflects the use that you would like to see made of your gift. So congratulations on arriving to this point, because a lot of people put off making a will, and we're glad for your sake, as well as hopefully for ours, that you've chosen to prepare some instructions and save your family from stress at a difficult time. I have a little bit to say just about the humanitarian legacy. When people talk about being humanitarians, most people know what you mean. But in Red Cross, there are some particular things that we do and we think we do, you know, as well as anybody, and perhaps some things that only we do. So a gift to Red Cross, if you chose to give one, and this is a no strings attached arrangement we have. It's a benefit that Red Cross is offering, so there's no expectation of a gift in this will, but all gifts are appreciated, and you can expect that they would be used to help us respond to disasters and emergencies, helping in humanitarian crises, perhaps supporting one of our international delegates. It might be used to help with Meals on Wheels. That's a program that's run for 70 years, offering more than a meal, but a strong, important connection to people in our community. Or perhaps your interest is in the area of our former refugee program. So lots of ways that a gift can help in the future once you've taken care of family and friends. And of course, an important element for Red Cross to ensure that it is sustainable, offering those programs in the future. So without much more ado, I just want to say thank you for giving this time today. We hope to answer your questions. I'm going to hand over in just one moment to Clarissa. So Clarissa is a trustee, as is Richard, at Public Trust. And it's important that you know that when you are online creating this will, that there is a real trustee who is able to chat with you online. It's not a robot. It's somebody just like the two folk who are joining us today. So thank you both for your time today. I'm going to hand over now to let you give us a little bit more information. Thank you.
Thanks very much for that. Thank you everyone for joining us today. As was said, I'm Clarissa from the Kapiti Customer Centre. I'm the Principal Trustee, and with me is Richard Hocking, who's a trustee from our Christchurch team. So let's get straight into it. Start off with a question to reflect on. How would you feel if you or your partner passed away and you were told that you had to pay out your partner's children to remain in the home that you shared? That may be one scenario that you or a loved one or a client that you interact with face if there isn't a will in place. I'll talk to you a little bit more about this later, but first let me share that approximately 50% of New Zealanders don't have an up-to-date will, and without a current will, you can leave your loved ones facing legal and financial difficulties. So today I'm going to give you a very brief overview on public trust. We're going to talk about leaving a legacy for those that are important to you. We'll go through the commonly asked questions, and they're things like the reasons for updating your will, how can you look after your loved ones in your will, the role of an executor and trustee, what happens if you don't have a will, and how to get started in that area. And we'll close off with what happens when making decisions during your lifetime. We will also be answering questions as indicated in the chat, and we'll keep an eye on those and check in at the end to see if there's any further questions there. And we're aiming to have this finished within an hour. So by the end of today's session, you'll have more information to move forward in protecting what matters to you, to people or organisations that matter to you most. And if you have any questions, as said, put them in the chat and we can do our best to answer them. However, please note today is time limited. So if your question is one that requires more personal details, we may refer you to the local public trust for some one-on-one assistance, but we'll do our best to cover off as much as we can today. And just a little flag there, the Public Trust website has got a fantastic amount of information on it. That includes, we've got all open information regarding our costs for wills, enduring powers of estate attorney and estate administration, and a variety of our other services. So please take the time to have a look. There's some great information in there, as well as any of our fees and charges. So let's just start briefly by a little bit about Public Trust. We've been around quite some time. We've recently celebrated 150 years. Some may not be aware that we're a Crown-owned entity. So we were established some time ago to provide professional and impartial trustee services, and that's just as relevant as it is today. Each year we write approximately 7,600 wills, and we manage the legacies of 1,400 of our customers through administering their estates upon their death. We'll cover off a bit more about our enduring powers of attorney, along with we're just mentioning today that we provide things such as a variety of different trusts, family trusts, funeral trusts, charitable trusts. We can also act for estate administration, whether as the executor and trustee or by providing support to your appointed executor and trustee, such as helping them with the probate service. We also do things less well known to some, as we audit the financial records of individuals appointed by the court as property manager for those people that are incapacitated. So that's all a quick view of the services that we provide. So let's talk about when you die, your life and your legacy. What will your legacy be? There are a variety of priorities when we think about that as individuals. And if we were looking at it from an analytical point of view, some theorists put it into three categories. There is emotional legacies, there's social legacies, and there's spiritual legacies. Without getting too much detail into the theory, emotional legacies are that we may want our loved ones to be left with an enduring sense of security and stability, that they've been nurtured and looked after and provided an environment of safety and love. There's social legacies. So that's, we may want our loved ones to be left with the skills of fine art, of social interaction, our ability to relate to people so that we can go ahead with our life confidently. And then there's the spiritual legacy side of things. So that's talking about we're wanting to leave a legacy to our loved ones of attitudes, beliefs about spiritual matters. The interesting thing from Public Trust perspective is that our recent research identified that 85% of people prioritised leaving an emotional legacy. That is, leaving our loved ones with an enduring sense of security and stability. Yet going back to that percentage I mentioned at the beginning, 50% of New Zealanders don't have an up-to-date will. And as someone that has been with Public Trust for 28 years now, I still find it really interesting that the statistic of 50% has remained relatively stable over that time. And so not having a current will remains a priority for Public Trust, and we're reaching out to organisations such as the Red Cross to provide information to people on how to preserve their legacy. So what can you do? If it's important to you, to say it with your will. And it's what do you need to consider when you're ensuring that your legacy plan is current? A will is a legal document that is uniquely yours. It sets out the wishes, it sets out the names of who is responsible for carrying out your wishes, and it gives specific directions on things like we've got on the display on the screen. The assets, anything you own over the value of $15,000. Now, just bearing in mind that it may not even be you that doesn't have a current up-to-date will, but have a think about your family. We've got a generation coming through today now, most have got KiwiSaver, so it's quite likely that they will have assets in the value of over $15,000 in their sole name. 3.5 million are recorded as having KiwiSaver. You can't own a KiwiSaver jointly, so it's quite likely that you will have an estate to administer. There's also things like friends and family. Who are you wanting to provide for? Even your pets. Mementos, what are precious things that you want retained by specific people? Bequests, such as the Red Cross today that we were talking about. Funerals, what are your wishes? Everybody's quite diverse in their expectations in that regard, and it can be such a relief to know what they are and a starting point for your loved ones. And then statements of wishes. Is there any other special instructions, things that you need to convey some clarity around some of your decisions or some more detail as to why? These are the types of things that it's important to consider and incorporate within your will. And just to take a little bit more chance to think on that a little bit some people think about, well, how do I know when to change my will? One of the things I do say is treat it a little bit like the smoke alarm. When it's time to change your battery, I think some people use it as daylight savings. Well, I think to also pull out your will and have a look then as well. Have a think about things like, have your relationships changed? Has there children been changes in the dynamics with your children? Has there been children born, sadly passed away, relationships broken down, or relationships mended? Has there been grandchildren? Are there any significant asset purchases, houses, KiwiSaver, life insurance? Is there changes in financial circumstances, inheritance, relationships starting or ending that change your financial circumstances, mortgages repaid, or developing savings plans? These are the things that are good little prompts that you might want to think about when you reflect on your own will and whether it is still current or the reason to have a will. A really big important part from our perspective is to think about the role of an executor. So what is an executor? An executor is who you appoint to carry out the instructions of your will. And from my perspective, there's three core options available to you. There is a professional, such as a solicitor or a trustee firm, such as Public Trust. There is a trusted individual, a friend or family member, or more than one. Or there's also individuals who oversee estate administration, engaging the services of organisations such as Public Trust to help them. An executor role holds a lot of responsibility, and it is a time commitment. Even financial liability can come into play with the actions that they choose to or not to take. And an executor can even end up being involved in legal procedures should your will be challenged. Some of the things that in my time I've seen an executor face are things like how to navigate the experience of grief. You know, if a passing of a loved one, it might be spouse, it might be parent, it might be child, and you're grieving as well as having to go into the zone of being an executor and put your hat on separately to go, how must I deal with these legal situations? How must I deal with tax returns, things like that? There is also the issue of conflict. Sadly, sometimes changes like these can either bring out the very best or the very worst in a situation. Blended relationships may come to the fore, and strained relationships may either occur or come back into view, coming together for the funeral. Time is something to think about. My experience when I did a little sort of check of that side of things, I think that there should be considered at least 20 hours minimum when there's not even a house involved. If there's a house involved, there's 35 hours plus involved at the very least. And thinking about, for example, today's market, the house may or may not sell in that time, and decisions as to what to do. Legal interpretation. Unfortunately, there are some poorly written wills or old wills, and then having to navigate what to do there. Overseas assets or family overseas is becoming a more common situation. And there's legal, as I said, legal obligations and liabilities, how you manage the funds, what and how you sell assets such as houses and who they distribute them to. And not to mention, of course, paperwork. There's lots of paperwork. Probate application, tax returns, financial statements, communicating to beneficiaries. So I just really want to reiterate that side of things, to think about that carefully when you're appointing somebody, whether it's an organisation or an individual. If it's an individual, do you need to have a chat to them about whether they want to take on that responsibility? If it's an individual, do you want to have the backup of somebody like Public Trust, just in case they don't want to do it or their circumstances have changed and they're no longer able to do that? It's really important transparency in the role, and I just want to emphasise, for example, with someone like Public Trust, the level of transparency and scrutiny we experience is such that we have a variety of avenues to make sure that that is a supportive environment for our beneficiaries. For Public Trust, our transparency goes as far as ministerial accountability, as well as we have an organisation such as the Financial Services Complaints Limited, which will independently audit our work, and we will honour any decision that they find, and that is free of charge to beneficiaries. So there's all these elements involved in being an executor, and something to consider when appointing one. What happens if you don't have a will in place? So a lot of people think that either it might all go to the government, it might all go to my spouse, but in some cases it may not. For example, when your assets are in the value of $15,000 or more in your sole name, the Administration Act determines what would happen. If there is a spouse or partner, but no parents, children, or other descendants, then yes, your spouse or partner will receive the estate. However, if there is a spouse or partner and children or other descendants, then the spouse will receive the chattels solely owned by you, the first $155,000 of your assets, and 1/3 of anything else left. The children would then receive 2/3. So circling back to my question at the beginning of today's presentation, if you think about the factor that maybe you have a house in your sole name and you've entered into a relationship, if that house remains in your sole name, potentially the house, I'm guessing, will be valued at more than $155,000. So just have a think again about how that would impact on those circumstances. What would happen to the house? Would your spouse have the ability to buy out the others? Would they have to try and enter into an agreement? Would the parties be willing to do that? Now, if there is a spouse, but there are no children, but there are parents, then in that situation, a spouse and partner receives the chattels plus $155,000 and 2/3 of the estate, but the parents would actually receive 1/3 of the estate. Now, if there are no surviving descendants, partners, spouses, blood relatives, then yes, in that case, everything does pass to the state. But for this process to happen, it's a lengthy process. It takes time, and it creates uncertainty in that time. An application to the court has to be made to access the assets and determine what will happen. You can ask Public Trust to assist you in this situation, but I do want to highlight that it does take time and it does take money. So by taking the time to have a will, it certainly makes a big difference. So just circling back to writing a will with Public Trust, have a think about the assets you have, what you might leave to what you have to leave behind, and things and who you'd like to leave it to. There's the ability to have a face-to-face appointment or write your will online. It can then be printed and signed and stored. It can be in a safe place such as Public Trust, which I'm a particular fan of because it is quite difficult to remember where people leave their personal papers. And then thinking about things change. You can just log back on if you enjoy the technical side of things here, or you can come back and see one of the team then. So we'll give you a little bit of a clip in a little bit later on to give you an example of the online experience. But one of the things, given the time that we have here today, I just wanted to cover off a few things about contesting a will. Some people like to think that anybody can contest a will, and sometimes you might even be privy to an experience where somebody says, right, I'm going to object to the will. It's not quite as simple as that. Not everybody can object to a will. There are 3 to 4 main particular acts of Parliament that impact on that. The first one is the Family Protection Act. The Family Protection Act says that there is a moral obligation to provide for certain people, spouse, children, grandchildren, in some cases parents, if there's like a role reversal situation, such as the parents are dependent and financially dependent on you. In some cases there are stepchildren or whāngai children where you have raised them as a parent and they are dependent on you. So the Act doesn't actually say what percentages you should provide. It doesn't say if you do this, no one can object to your will. It just simply says that there is a moral obligation. So that's a wide open book. And so there's been various considerations over the years to that type of thing, and when it's gone through the court. To give you an example of one, there was a situation where there was an only child of a deceased person who was provided at that time $190,000. Her 3 children were provided $1 million each in a trust fund, and then the remainder of it went to a charity. The deceased did not provide anything further for the daughter. He had a low opinion of her husband's business acumen and work ethic, and had previously supported them in their business endeavours, and was very disappointed in how unsuccessful that had been. The daughter had a home with a mortgage and a modest income, and she made a claim to say that she did not feel that she had been provided for as morally she should have been. The court determined that a wise and just testator, will maker, would have ensured that she was at least debt-free of her home and supplementary income. Therefore, the court awarded an additional $855,000 plus funds to clear the mortgage. That moved the provisions for her under the estate to approximately 20%, and that was considered by the court to breach the moral duty, to repair the breach of moral duty. Now, the Testamentary Promises Act is another act. It's probably a little bit less well known, but it is coming to the fore in more recent time. The Testamentary Promises Act says it's not you can have this when I die, such as you can have my engagement ring when I die. It's if you do this for me, you can have this when I die. If you mow my lawns 10 times a year, you can have my lawnmower when I die. Probably a less common known one, but more likely you'd see a situation where, look, I really need some help within my home, but I can't afford to pay you. I really don't want to go in, for example, to a retirement facility. So if you come and look after me in my home, I'll make sure that you're looked after in my will. And maybe the person came and cared for you for 10 years and you left them $500. They might decide that that's maybe not equivalent to the promise made and take a claim under the estate for additional provisions. An example of such a claim, now bearing in mind this was back in 2002, an individual claimed that the deceased had promised to leave his farm to her in return for assistance around the house and farm for the last 9 years of his life. The support was not extensive, but equally it wasn't trivial. The claimant actually, throughout the proceedings, falsified diary entries to produce as evidence to advance her claim. The estate at the time was worth $260,000. The court initially awarded the claimant $30,000, but on appeal awarded her $120,000, saying that the judge had placed too much weight on her fraudulent misconduct. Finally, the other act that I particularly want to mention is the Property Relationship Act. Now, that act is a relatively new act that says that if you're in a relationship with somebody, whether marital or not, they have a right to be provided. The act in itself is actually very broad in what it determines as a relationship. I won't go into the detail of that, but it's just important to bear in mind that, again, having a current will is important, making sure that you've considered what provisions you want to make for your partner. There's other factors that can come into play with it. For example, if you die without an estate, that's what we call an intestate claim. People who die without a will can still have claims made against the estate under any of these acts. One such case was awarded where a neighbour made a claim on behalf of their children. The award was the farm valued at $1.4 million, and that was due to the neighbour making a claim that they had provided meals and included them as a member of the family for an extensive period of time, and that was awarded and upheld by the court. So by having a current will, it may not stop challenges to your will, but a current will means that you express your wishes relevant to your situation, and then you have the comfort of knowing that you've made the best possible provisions for the people that you care about. So I also want to circle back at this opportunity to emphasise the role of the executor. I'm sure you can imagine if any of these proceedings that we talked about today, it would be time consuming and quite stressful to be involved with. So just emphasising again to choose wisely about the executor that you appoint. So that's talking about when you die. What happens during your lifetime? Who makes the big decisions while you're still alive? Now, there's a couple of aspects regarding that. What I'm going to do is I know I can't see raised hands or anything on the session today, but I'm going to ask you a queries of sessions and just have a think to yourself whether these circumstances apply to you. How many of you have been for a walk to a location for Sunday lunch or gone for a motorbike ride on a Sunday? How many of you have gone on holiday and you've had a tourist walkabout to explore the area? Now, I know it's not particularly health and safety wise, but how many of you have been doing DIY Kiwi activities and maybe you've been doing building or renovation in your home and you've stood up on a sawhorse or a ladder? And then a little bit more of the hygiene side of things. How many of you have a morning routine when you get up in the morning? It might be that quite naturally you get up in the morning and you use the bathroom facilities and then have a cup of coffee before you get on with your morning. If any of you have said yes to any of these situations, then enduring powers of attorney are important to you. And in fact, enduring powers of attorney are important to anyone over the age of 18. Some people say, look, I get that sorted out when I've retired. No, it's not. As of those scenarios that I've talked about, could it be anybody? Now, just to give you the background to each of those, I'm talking to the situations that have impact on my family or friends, and it may sound that we're a little bit accident prone, but I like to think it's possibly that I've become more aware of them because of my role. So for those that have gone for a walk or a motorbike ride or anything like that on a Sunday for lunch, my grandmother was returning home from a luncheon that she had been out and she was coming back on her mobility scooter. And unfortunately, a car came out of a driveway in a blind spot and hit her. The impact of the fall, she fell off her mobility scooter and hit her head. And unfortunately, it caused multiple brain bleeds that were non-recoverable. That ensued time of needing to make decisions about her health as well as her legal and financial situation. How about a tourist walkabout? From my early years of public trust, I always remember this one because the daughter had always asked me to share it with as many people as possible. Her father went for a walkabout just to do the normal touristy explore. He slipped on some gravel and unfortunately, again, a bit similar to the way with my grandma, the way where he fell, he became paralysed from the neck down. He was an extensive period of time in Burwood Hospital, unable to sign and attend to any of his legal and financial matters. When we're talking about standing on a ladder or on a sawhorse, a family friend of ours unfortunately fell from a sawhorse and fell onto concrete, and similar to our client, landed on the concrete, causing paralysis damage and ended up in Burwood Hospital for a very long period of time, again in similar circumstances. And again, without lowering the tone of the conversation, when we're talking about our morning routine of, say, maybe going to the bathroom and coffee, statistically, did you know the most likely and common area for a person to collapse, or the most common area and have a stroke or a heart attack, is in the toilet and bathroom? And my grandmother-in-law sadly experienced that herself. She was living alone quite well and independently, and sadly suffered a major stroke in the bathroom, and unfortunately she wasn't found for quite some time. That left her completely impaired. She could actually walk, but she was physically unable to speak, and she then resided in care for quite some time. That meant that all of her legal and financial matters needed to be dealt with, the house needed to be sold, residential care needed to be found and admitted to it, residential care subsidy applications needed to be completed. So each of those situations is relevant to somebody young or old. An enduring power of attorney means that information, decisions and actions needed could be made immediately without the delay of court proceedings. So an enduring power of attorney is where you appoint somebody. You have two parts to it. In an enduring power of attorney for property, you are appointing who makes the legal and financial decisions if you're not able to, how to sort out the bank accounts, the house, filling out application forms, or who making sure the house is insured. where you go and reside and paying that bill. And then the enduring power of attorney for personal care and welfare, that's making decisions about your health and well-being if you're not able to do so yourself. Where do you reside? What type of treatment you have? What type of decisions regarding your ongoing care are required? Some people might say to me that, look, I own everything jointly. That doesn't matter. I don't need it. That's not entirely true. Again, referencing the KiwiSaver, you may have a KiwiSaver, or you may even own a house jointly. Now, if you own a house jointly and one of you is unable to sign, unfortunately, the other person can't just sign for you. They need to have an enduring power of attorney, and that needs to be presented to the land transfer office when the time of selling the houses occurred. Same as if they needed a mortgage to restructure, renovate the home, or if you were selling and buying again to be closer or a more mobility friendly home. So that could be a jointly owned asset, but it still needs an enduring power of attorney. And again, just emphasizing that having a next of kin does not help that situation. The legislation, when it comes to things like Privacy Act, things like that, an enduring power of attorney is still required. So what we're going to do now is that, beg your pardon, I did want to actually mention to you, when you're thinking about the enduring power of attorney, do have a think quite carefully about who you appoint. It's very, very similar to the executor. Who is going to make good legal and financial decisions for you, or good decisions about your health and well-being? Who best knows your situation? In my early days of working, I quite often found that people would go and pick the eldest of the family or the eldest son for legal and financial. The question was, are they good at making legal and financial decisions? Do they have the time to make those sorts of legal and financial decisions during your lifetime if you are not able to? And just a statistic I do like to share from Age Concern is that 70 to 80% of abuse of our elder people occurs at the hands of family. And that unfortunately can include financial decisions. So it's really, really important that you think carefully, and equally that you make the decision about who you want rather than having the decision made for you. And another thing to bear in mind is that over the years, life expectancy has extended. It's actually doubled over the last 200 years. And there is also a statistic and projection around at the moment that if you're age, say, 12 at this point in time, over 50% of them will live past the age of 100. So we're living longer, and our needs therefore must be considered, and our ability to have support, live independently or live assisted, really important matters that could impact for quite an extensive period of time. So an enduring power of attorney is a valuable document in that time. So just moving across from this slide here, all going well, I'm just going to click on the link, which is not always my forte of thing, and we're just going to give you a little bit of a snippet of our online system just to show you how easy it can be to get these documents underway. Just extending on from that, I just wanted to also take the opportunity as valued supporters of the Red Cross, just to show that we've made it really easy for if you wish to make any provisions for a chosen charity. So in the case of the Red Cross, When you log on and sign up to do your will online, you'd enter into your various details here. And as mentioned, you deal with humans if you have any questions, which is wonderful. One of my pet peeves in technology these days. And then when you go in, there's a question asked saying, do you want to make any specific items to a specific person or organisation? You go yes to that. And you might want to, for example, leave a cash sum. You put how much it is that you would like to provide. You select a charity. And as you can see here, some of the common charities that we have picked are readily available. So just as easy, you can click on that. It's really important when you're providing for charities, you have the right legal reference, because there's numerous ranges of charities. So this way it's got the specific legal name of the charity and their charity number. So really easy to select and provide there should you wish to do that. I also just wanted to close off and thank today for your time and the opportunity to speak to you. I also want to give a shout out to, I had a wee look at the Red Cross resource of My Life and Legacy. I think it's fantastic. As somebody that administers estate, it is so helpful if people come in with information or gathered in a booklet or some form of resource such as that. And I just thought that had a wonderful array of questions that were really, really helpful at a time. Reflecting back to my experience of my grandmother when she passed away, not only were we sort of in grief, but we were also still in shock and really, really tired. And I remember one of the things she asked me to do was, hey, I need you to go and get this piece of paper when I died of what she'd written. I had to go into the house about 3 times because I was so tired from lack of sleep, and I just could not remember for the life of me where it was. But by having a booklet and it all contained in it information, I just think that's wonderful. So I'd really encourage you to take the time to utilise that resource. So I was just checking in to see whether, Richard, did we have any questions more to raise?
No, we have just had the one question in there, I guess, around providing specific instructions for assets such as a family home. So it's something that you can, I guess, specifically, put a custom clause in terms of your will. I guess sometimes with that, we want to make sure it kind of is set up obviously in a practical way. So it can be worthwhile maybe making an appointment to speak to someone, but you can also through the online platform request an expert review once you've sort of structured your will. So there's a couple of ways that can kind of be accommodated, but no other questions that are there at the moment. But yeah, happy to take any other questions if there are any that have come up.
Right. And one of the things that's really worthwhile having a conversation, if you want to have more of the face-to-face conversation, is to think about the way your property is owned. You may have it owned solely, and we talked about that from an intestacy point of view. You may own it jointly, or you may own it tenants in common, or you may own it in a family trust. Each of those have implications and options available to you when you pass, and particularly in those circumstances such as a blended family situation, it's so valuable having a conversation about what options are available to you. I also just want to emphasize that I over the years, I've spoke to various groups, and some of them are, for example, where they have children that are dependent on them. They may have disabilities. And so often I found that they left it for quite some time before they came in because they thought the situation was insurmountable. What were they going to do when they died because that person was dependent on them? Do come and have a talk to us. It actually is something that we can offer options. It's something that we deal with on a daily basis. We have a wealth of expertise in that area. So even if you think your situation is unsurmountable and you'd like to have a chat and come and explore through the face-to-face option, do give it a go, do reach out, and we certainly will do our best to see what we can do to, at the very least, provide and go through the options available to you to do the best that we can for you.
I guess just a couple, Chris, another question that's kind of popped up, might be easier to talk through. What about overseas assets and how can that sort of be structured and managed? So you can, in your will, especially through the online platform, include a clause that does say that your New Zealand will can account for dealing with the distribution of any assets that are overseas. The other option is that, say, if you have assets that are overseas in the UK or in Hong Kong or other countries, you may want to look at making a will in that country that deals with that asset to make life easier and make it more simpler. I guess typically speaking from a New Zealand perspective, it's easier, so to speak, to administer in a state that has overseas assets that are in Commonwealth countries, because of how our laws are recognised, and they do tend to be similar. But either way, if we do have overseas assets accounted for in a will here in New Zealand, it can create some complexities in terms of calling those assets in, or actually causing delays, and can create some further costs. So something that can be done, but there are different ways in terms of what that might look like.
That's great. And I'm just thinking, in the absence of any other specific questions, I thought I'd cover off some of the ones that had been specifically raised. What happened from other ones that we commonly hear? What happens if we don't have a next of kin or a family member that could help us with an enduring power of attorney? So that's a prevalent situation, or someone that you trust. You do have the option of having somebody like Public Trust appointed as your legal and financial affairs. And so we are there as an impartial person, organisation, to look after as little or as much as you want us to do, and just provide you there with that impartial, independent support. Yes, we would charge on a time and attendance to do so, but it gives you the option and peace of mind of knowing that we're there if you need us. The cost would be to set up the enduring power of attorney. If we were never needed, there wouldn't be any further cost with it. If we were needed, we would sit down with you and discuss what it is that you want us to do, and we'd go through the costs of that. So there's always options available to you. I also wanted to cover off, just for those that have young children, or they're thinking of their family that, such as their own children, that maybe don't have a current will in place, or a up-to-date will in place. So just have a think about guardianship, things like that. Life insurances, how are they going to provide for their children? Particularly if they're young, what happens to them insofar as that the will can cover off what we call testamentary guardianship. So who's involved in the decision making? That can be a really important matter if either both parents pass away, or the parent who's the primary caregiver passes with leaving assets. So something as simple as making sure that the right people are involved and that child is provided, or children are provided for, is so important. Also, just I want to flag that when you're talking about overseas assets, it's well worthwhile looking about whether there's options that would be better served by having a will pertaining to that particular country. So again, have a chat to a trusted advisor such as Public Trust or your solicitor. And again, thinking about those situations of if somebody is living in your home that's dependent on you. I'll use my grandmother as an example. My uncle was living in the home, and he was dependent on her. So she had made provisions that he could reside in the property for a further period of time, to just give him time to adjust, explore other options of what he wanted to do, and so that just gave him a bit extra time, but gave some stability and security to him at that time. Māori land is another common question. Māori land primarily can be dealt with through the Māori Land Court. It's a fantastic organisation, quite a bit of paperwork, but lots and lots of guidance available to you there. So do have a look in that, do a wee Google on that, and there's some great guidelines of what is required there. So I think that was about all that we had to cover off. Caroline, was there anything from your end of things from the Red Cross perspective?
Thank you. I just comment that I think we've had some really valuable instruction today, and information which I suspect a great deal of it was not known to this audience. So thank you both very much indeed. A few takeouts for me. I know that in our audience today, there will be people who have written wills before, and people for whom this will be the very first time. And it can seem, like quite a lot of information to take on board. My advice would be just to get started. Don't forget, once you've got the login, you've got the opportunity to look through the site, and you can invite a friend or a family member to sit with you if you chose that, just to give you the necessary confidence. You don't have to be amazingly good with technology. There's a bouncing ball to follow. And I have had conversations with our friends here at Public Trust who have said, most people, even the most nervous, 98% of people can do this. And so the opportunity to get a free online will is just there for the taking, really. And it's something that one day you'll get round to, but sooner is certainly better than later. So, yeah, I can't think of a better reason to get a few thoughts down. Maybe using the My Life and Legacy booklet. As I've said, we've had a lot of feedback from the public that has told us that this has been very valuable preparation, and then you can put the information into the will itself. It's available on our website, so you can download it and you can then fill it in. You can share a copy and keep it with somebody else if you'd like to, or you can obtain a proper copy at that email address, bequests@redcross.org.nz. I would probably say my last comment is, for many people, this is a really distressing time. You're going to feel good about doing something good for your family. A lot of what we've talked about this afternoon probably feels quite sort of doomy, gloomy. Nobody wants to go there. But it's inevitable. If you've got stuff, you need to protect it. It's a pretty low threshold. I think I heard Carissa say $15,000, in a Kiwi saver. That would be enough to have to go through another whole administrative process to be able to administer that. So, yeah, the advice that we're getting can help you to just preempt the pitfalls. So, try and look on it as empowering. Something you can do to prepare yourself and family. And thank you both, Richard and Carissa. We are going to circulate this as a recording in a few days. Give us perhaps 2-3 days to just put that together. And so you can revisit it again with somebody else in the family if that's helpful to you. And always help at the other end of the phone at Red Cross. So don't hesitate to contact us. bequests@redcross.org.nz and just request somebody give you a call at the time it's convenient. So many thanks indeed, and good luck with the will writing.
Thank you, everybody.
Thanks now. Bye-bye.